I got 5 minutes to go.
Yes, I'm sorry about that. I knew, and I suspect, well, I didn't know. I thought it was almost certainly a test, but that does not mean one couldn't take it seriously. So there we are.
No. In terms of the approach then to statutory interpretation, we emphasise that doubtful penalisation and absurdity are not starting point principles. Those are principles that may assist if, for example, there is ambiguity, such as doubtful penalisation. We say that the statute is clear. The meaning that we've set out in our 7 bullet points in the draft declaration gives effect to all of the words in a way that gives them their natural meaning. And that is how one starts with the process of statutory interpretation, and usually where one ends as well. So one does not start with an accused position, well, it's absurd, so it can't be right. That's simply not how this operates. It's perfectly legitimate simply to apply and interpret the ordinary meaning of the language, which is what a more detailed declaration achieves. And the point simply boils down to what the science will show about the particular breed selected by the keeper in modern commercial conditions. That's how it is going to then operate in reality, and it is a simple measure when considered in that light. Very briefly on A, I think the court has this point, but paragraph 46 of A...
Sorry, can I just...
Yes, of course.
Simply because it may be that you covered this just before the fire alarm went off,
Yeah.
and I didn't write it down because of the fire alarm. But I think the last thing I did write down before lunch was that you said that the points reflected in declarations 2.1 to 2.3
Yeah.
were broadly agreed.
Yes.
Obviously, the principle of the declaration definitely
Of course.
is, but and the issue you identified was over 4, but did you actually address the actual point that's raised by 4 reasonably expected by a keeper operating in ordinary farming, commercial farming conditions? If you said something about that, I'm afraid it got lost.
Of course.
In the fire alarm.
Secretary of State's argument is that effectively one reads back to section 9 primarily, and then one interprets section 9 with what we would say is a gloss. One reads that as meaning any conceivable conditions that might then mitigate the effect of the detrimental effect. And what it says, it refers to just good practice. The Secretary of State says then that is the framework within which one operates, a hypothetical situation in which one can bring to bear, using science presumably, some means of amelioration. And therefore one can select the breed, even though one is not in fact going to ever ameliorate the problems identified. That doesn't matter, because in principle a keeper could do it. That's Secretary of State's argument. We say plainly wrong. What one does is simply consider this by reference to ordinary commercial farming conditions. In the case of these chickens, that is Schedule 5A, other animals, other statutory provisions underpinning them, or it's just the general statutory framework.
So is that right? Would it follow from that you'd say that even if in ordinary commercial farming conditions somebody could not keep a particular breed, but somebody who is prepared to put in the appropriate mitigations or changes is just not allowed to do so?
Just to be clear then, so if it is theoretically possible that one could do it, but we would say no, you cannot do it if, broadly speaking...
Well, if in practice you can do it, it just will cost more money to do it. Are you saying that because, quote, an ordinary commercial farmer wouldn't, that somebody who is prepared to put in the expensive mitigations is not allowed to?
Yes, it's not operating at that individual level. It has to be operating at an industry level in terms of either allowing the breed to be chosen by the keeper or not allowing the breed to be chosen by the keeper. So the fact of a theoretically possible...
But I understand that if something is only theoretically possible, but it would cost £3 billion for an individual farm to do it. Mm-hmm. That's not ever going to happen in the real world. But that's not the situation I'm postulating.
No.
I'm postulating somebody who could, and a company which could, albeit that it would be expensive, but an affordable amount.
Sorry to interrupt. Look, in a sense, it's enough to say, albeit that it would be more expensive.
Yes.
Not necessarily that it would be particularly
Then there's a
expensive.
reasonableness issue that's engaged here. So it's the reasonableness bites here. So one can have a range of reasonableness, which won't mean that the mitigation is so straightforward that it's within then the concept of reasonableness to assume that it is fine. So that's why the reasonableness consideration, which involves a possible different set of conditions, which are also still commercial farming conditions, would then be brought into the analysis. So you
sorry to interrupt, but
yeah.
I may have misunderstood you earlier. I thought when you were saying normal commercial conditions, you were equating that to the minimum standards required by the substantive provisions of Schedule 1. But it sounds as though you're not being quite that rigid.
No, not being quite that rigid. They are the best indicator of what commercial conditions are, because it's a competitive landscape, they're in it for profit, they will operate essentially above the minimum, but it is unlikely that they are going to be significantly above that, because that will have a cost and therefore bear upon competitiveness. So broadly speaking, one can look to the regulatory framework as being the best indicator of what those commercial farming conditions are. There may be evidence of a better set of conditions, which notwithstanding the fact that it's not required by the statute. My Lord Justice Snowden's proving this.
This is not a simple black-white, I don't want to spend more money type analysis. Suppose a farmer just decides, look, I don't want to go the full organic hog. Sorry, I don't want to go the full organic. I don't want to get more eyeballs into this equation. I don't want to go the full organic and therefore get out of these regulations completely, which is what you would.
Yes.
Because I can't afford that. But I would quite like to sell faster growing chickens that I can advertise or market on the basis that I have mitigated any of the problems associated with fast growing chickens.
Yes.
And I appreciate that will cost me more by way of capital outlay to put in place some mitigations. But I reckon I'll make up for that because I can charge more and sell more.
Yes.
Are you saying that that's impermissible because somebody, an ordinary commercial chicken rearer, who this hypothetical ordinary commercial chicken rearer wouldn't take that view, therefore wouldn't mitigate, and therefore paragraph 29 would bite on it?
I am saying that, absolutely, because of the way that the words operate. They operate effectively as is common ground, choice of breed. So that is looking at industry-wide, the sort of options that are on the table for the keeper. One looks at that, broadly speaking, across the industry. One does not then take into account the possibility that there is an extremely benevolent keeper somewhere in the country.
It's not benevolent at all, he's just deciding to do it for commercial, it's his view of what commercial gain amounts to.
Very well.
I'll make more money in the long run.
Yes.
Spending more now, putting the chickens into better conditions, but they're allowing me to therefore rear the faster growing ones because I can sell them for more money.
I absolutely understand the hypothesis, but the issue is then either whether in fact that's still within the reasonable commercial conditions, which, as I said in reply to the Vice President, I'm not saying it is simply a matter of the minimum. They're a good indicator of what those conditions are. But my Lord's example might be a farmer who is still operating within that range of commercial farming conditions. It's likely to be a pretty tight range, we would submit. Doesn't matter, falls for consideration on the facts. In the particular situation, whether the word benevolent is correct or not doesn't matter. But if one is in that situation where it is not something that resembles ordinary commercial farming conditions, can they nevertheless do it? We would say no. I appreciate that one might say, well, that's slightly odd and unfair on that particular keeper, given that he's actually trying to do everything he can to promote the welfare of the animal. But this is not looking at the individual keepers.
This will be criminalised for it.
Indeed. Yeah, but the point here is that it is basically about breed selection, And
You keep saying it's about breed selection, not. It's about breed keeping.
well, issue 1, paragraph 1, is about the choice of breed to keep.
What do you say, paragraph 1? What's paragraph?
Oh, sorry, of our declaration. So that the point.
Yes, I know, but you're not sure that doesn't mean your declaration is right.
No, but the starting point of how we're all interpreting what paragraph 29 is designed to do is that it is about choice of breed. So,
Well, that's true in some rather broad economic sense, because people will not choose to keep a breed which they commit a criminal offence by keeping. But,
yes.
but the choice isn't part of the statutory test. The statutory test is may not keep.
Yes, indeed. But it follows from our submissions as to what the ordinary meaning of the language is, that there may well be a hypothetical situation in which that farmer says, well, I have seen that in substance, although not in reality, there's effectively a list of breeds which the science demonstrates can no longer be kept, just for the sake of argument, in ordinary farming conditions. Keeper says, well, I'm not an ordinary farmer, so what's the problem as far as I'm concerned? But there is no escape clause elsewhere in the regulations that allows the keeper to do that. That is simply a fact of
There is an escape clause. The escape clause is that if he is then prosecuted
Yes.
for keeping one of those breeds, he will say, I reasonably expected they wouldn't suffer any detriment because I was giving them twice as much space.
Well, that's in a subjective approach of reasonableness.
No, it was reasonably expected by anyone who knew that I was going to keep them in 200 in twice as much space.
Well, we would say that's not the right way to read it. The reasonable observer then is looking at conditions generally as opposed to the specifics.
I think it must. The reasonable observer it must be looking at the circumstances of the particular person, of the particular keeping.
Well,
It's objective, but each act of keeping must be judged by the same objective standards. And if it's part of the relevant circumstances, that it will be kept in circumstances where it won't suffer harm because successful mitigating measures have been put in place, why isn't that the end of the story and produce a more sensible result?
I see the way my Lord puts it, and indeed, frankly, we would have no complaint if the outcome were that one is not looking at Secretary of State's position, which one says, well, is it hypothetically possible whether or not the keeper is putting in place those mitigatory factors to keep the breed? Because that's the Secretary of State's argument, which we have a real problem with. If, in fact, the position is, no, you actually look to the individual and have they somehow, we say can't be done in the two specific instances, say, for example.
Well, I mean, of course, I understand part of the difficulty is we're looking at this in the abstract. You say this is all very interesting, but can't be true in the case of these chickens. Well, and you may be right about that, but we're not going to be deciding that today.
No, might not be deciding that, but I see the force, and obviously the debate is helpful. One could have a situation which is very far from how the Secretary of State would have it then, that the keeper is somehow able then to deal with, for example, the circulatory issues. But that is squarely not how they put it. They say,
I'm not sure that isn't how they put it, but in any event, we've got what your position is on it, and I don't think we should take advantage of the fire alarm to prolong the point longer than we need.
No, well, certainly then, I maintain primary submission. The fallback would be to adopt that in the sense that if that is a more sensible reading, then providing it has that very important qualification that on the individual case, it is not just whether it is possible for the innkeeper to actually be remediating the problem, but they're actually doing it. So it's not the Section 9, look at the code of practice and see whether it's possible. It's an actual interpretation which requires science somehow to have remediated the problem. Then the issue falls away. The welfare concern is then met, and that meets certainly our concern.
Okay.
So I hope that assists.
Yes. What other points did you want to make?
What other points? Supreme Court, the Court has this. It is why this is certainly not the case that there is a clear steer from the Supreme Court that it only applies to incorrect positive statements. That was the Secretary of State's submission. It is very clear that the three categories are set out in A includes omission, and one considers it taken as a whole. Here, the importance of the code of practice could hardly be overstated, given the various other aspects of the legislative regime. And we say that the code plainly is misleading by omission. There's this specific point on 332 of the code of practice. It was said that that only concerns parent chickens, but the heading, which appears above paragraph 28 and 29 on that page, not necessary to go to it, says it is concerned with all meat chickens. So I would not accept the proposition that that is intended to be limited by reference to the heading that appears at the top of the page.
Do you accept that the Secretary of State is not under any obligation to issue a code?
No, I don't accept that. So it doesn't matter because the Secretary of State has, and this is what we touched upon yesterday. If the response to this judicial review were to withdraw the code and then to do nothing, I would not accept that that would necessarily be lawful in the circumstances.
Well, what you'd have to say, and to be fair, I think Mr. Turney accepted in principle, you could say, it's arguable you could say, is that it was irrational of the Secretary of State not to issue a code. It's only a discretion, but in the circumstances of conventionally reared chickens, it was irrational not to. That's how you tried to put it.
I would probably put it in that way, absolutely. So I certainly would not.
There's no other way you could put it, is there?
Well, I'd keep my powder dry. Certainly, irrationality is the obvious.
Fair enough.
Well, of course, but yes. So for the sake of argument, irrationality, and therefore we would say no. More fundamentally, it is a very curious position for the Secretary of State to be adopting, to ask the court positively not to give this authoritative interpretation of the law, when the Secretary of State himself is not doing so on his own case in the Code of Practice. And he is positive.
Is he under any obligation to give an interpretation in the code of paragraph 29?
But the court has a constitutional responsibility to interpret the law if that is put before it, as we say it has been properly done. So the judicial review has permission, and therefore the court is seized of the matter, and we say should then determine the meaning of the legislation, give plenty of authority in support of that. Why is the Secretary of State saying that this should go to a lay magistrate with no legal training, who will just acquit or not on the basis of what we would say is a misleading code of practice, or at its highest, a very ambiguous one?
There might be a district judge who would have.
Maybe. Maybe a magistrate, maybe a district judge. It is odd. And the divisional court in Roberts and Ruggiero...
You can't start it that way. A court is a court.
A court is a court, yes, but this came before the divisional court in Roberts and Ruggiero. It said, quite similar, it's not really suitable for the magistrate's court. That was what Mr. Justice Stoker said, tab 6, page 325.
Well, fine, but it's in the magistrate's court, and if they get it wrong, there's always an appeal route.
Yes. Well, the only observation I make is that this court has had the argument, as indeed the court below had. Everybody agrees that you're here, or being respectfully invited, to tell us what the provision means. It's not really an answer for the Secretary of State to say, well, don't.
I don't think he is saying that.
Very well. In which case, I'm not sure what he's
saying. Well, that wasn't my Lord's question.
No, I wasn't really asking about what this court should do. I was simply asking, because there has been some discussion about it, what your position was on whether the Secretary of State was under an obligation to give an interpretation in the code, and your answer is no.
Under positive obligation to give an interpretation in the code, I said no. What the Secretary has to do is comply with the principles in A. So they can't be misleading by omission. So one has to simply consider this by reference to what A says about codes. So I've also said that I would not accept the proposition that Secretary of State can simply do nothing at all. So I think where we are is that in circumstances where the code has been promulgated, that we're entitled to challenge it on the basis that it is self-evidently not directing attention properly to the constituent parts of paragraph 29. And that is sufficient for present purposes. If the consequence of this litigation is that they just withdraw it, we will consider that matter carefully, and no doubt there will be further legal arguments thereafter. I take my Lord's point about the Magistrates' Court. This wasn't intended to be a criticism, but there is authority in the bundle, albeit it is only a paragraph in the Divisional Court's judgment in that particular case, which simply indicates that actually this is the best way of resolving these particular points, because...
But look, I don't know what we're arguing about.
Very well.
Everyone accepts that, given where this has ended up, we have got to offer a construction of the of para 29.
Yes. In which case, I will not trouble the court further on that. So that concludes my reply. Thank you very much.
I'd like to thank all counsel, both those we've heard from and those behind them, who I'm sure contributed, for careful and well-presented arguments. This is obviously a very important case, and we're going to need to take time to think about it. We will be reserving our judgments, and I offer no prediction as to exactly when they will be handed down. In advance of hand down, they will be circulated in draft to counsel in the usual way for the limited and specific purposes defined in the Counsel General for Wales case, with which counsel will be very familiar. If they are circulated for any other purpose than other than for those purposes, there may well be a contempt of court. So it's important that those they only be circulated to the limited extent necessary. Thank you all very much.
Why is it available?